just keep doing what you're doing. Even if you're reading just one page every day, that matters, that counts. Okay. All right. So is there any question? A question that is coming from the previous class, or a question that is coming from your reading or anywhere, as we can address it. We can address it. Okay. So because of time and there's no question, I'm just going to throw us deep into something that I wanted us to discuss quickly. That is the question that I promised we will look at. And then we can dive deep into our discussion today. So we're just going to go through this question and see whether it is something that you can score or something that you cannot score. Okay, guys, like I've said, exam questions are not out of this world. Exam questions are just very simple questions. They're normal things. Okay, the same questions I'm asking you in class. Those are the exam questions. They're not out of this world. The only thing that makes you want to fail is because you're overthinking that question. The question is very simple, a very, very simple thing, but you are really overthinking it. You're really, really overthinking it. Okay, you're crazily overthinking it. So I want us to see how best or how worst you can overthink in this question. And then we can move forward and address, whatever we need to address today. So you can see my screen, confirm you can see my screen. If you can't see my screen, you need to confirm you can. All right, so this is October 2022, question 1, which is civil. So I want us to read this question, and this question is civil, guys. It is a civil paper. Okay, it is a civil paper. It has nothing to do with. It has nothing to do with conveyancing or anything. It is a civil paper. Okay, civil papers. There's no reason why the examiner will set for you a conveyancing question in a civil paper. No, it's just a civil paper, though it might have some few things that you've seen from conveyancing. So I want somebody that is reading. Maro, are you here? She is not here. So I want somebody that is reading very clearly to read for us question 1. As you read the question, understand the question, internalize the question. Okay, internalize the question, and this is how exactly exam questions are set. So let us proceed. Somebody read for us. Somebody that is confident with their reading.
Scroll the question.
Oh, sorry. Let me do that now. All right, the question has been scrolled. I don't know why you can't see it. Mine is scrolled. You can't see?
It's still not reflected, and it's still on the first page.
All right, let me reshare. All right, so let's read the question and see. Somebody. Guys. Yes, Penina.
Oh, yes, Mwalimu. I'd like to read the question. So, question 1. You are an associate at Magonda, and
Magonda.
yes, Magonda.
You need
You
wait fast. Guys, when you're reading an exam question, you have to be very keen. Don't miss points. Okay, because if you can't get a name clear, you might miss some few things along the way. Okay, so let us proceed. You're an associate.
Apologies for that. You are an associate at Magonda and Company Advocates of P.O. Box
You can skip
6738.
that. Just skip
Okay,
that and go to one of the associates.
Okay, that email, and then one of the associates in the firm has instructed you to take instructions from Joseph Ngolu of PO Box that on 16th August 2018, Joseph gave you the following instructions. In July 1987, Joseph purchased all that parcel of land known as Nairobi Block 17/68 from Samuel Joe of P.O. Box, that Thika, at a purchase price of Kenya shillings 20,950,000. By then, Samuel did not have title to the land, but was in possession of a letter of allotment. The total purchase price was deposited with Ndimo and Company Advocates in terms of an agreement dated 26th July 1987. The advocates paid Samuel a sum of Kenya shillings 15,445,000 on the same day. The balance of the purchase price was to be released to Samuel upon him procuring the title and consent to transfer the land from the Commissioner of Lands within a period of 6 months from the date of the agreement. Joseph took possession immediately upon execution of the agreement, fenced the property, and deposited building materials worth Kenya shillings 5 million, and has since been in occupation. Joseph never got the title to the land. Ndimo and Company Advocates paid the balance of the purchase price to Samuel, despite the fact that no consent had been obtained. Joseph followed up the matter and found that a sum of Kenya shillings 29,000 being, Mwalimu, kindly scroll up, and found that a sum of Kenya shillings 29,000 being arrears of land rent had not been paid. Joseph paid the said amount and the title was prepared and forwarded to Ndimo and Company Advocates. The advocate prepared a transfer of the land, but Samuel refused to sign it. On 2nd May 1995, Joseph placed a caution on the property to safeguard his interest. Samuel passed away in May 2000. His wife, Lucy Joe, obtained a grant of letters of administration in January 2004. She has now threatened to forcefully evict Joseph from the parcel of land. Question 1A, write a legal opinion on the steps Joseph needs to take to have the property transferred to him and the issues you will consider before drafting any pleadings.
Yes, that is how exam questions are set. It's as simple as that. Okay. Now, some of you are already thinking about conveyancing. You're already going out and overthinking. Don't overthink this question, guys. It's a very simple question. This question has nothing to do with titles. This question has nothing to do with conveyancing. This thing has nothing to do with conveyancing. It has nothing to do with titles and the transfer of titles. It has nothing to do with that. This is purely a civil suit. Okay, this is purely a civil suit. Now, write a legal opinion on the steps that you will take or you will need to take to have the property transferred to him, number one. Number two, and the issues you will consider before drafting the pleadings. The issues you will consider before drafting the pleading. So there are two things there. There are two things there, guys. The first one, always when you read a question, you have to read both parts of the question. That question has got two parts. What is the procedure you will need to take to have the property transferred to him? And then what issues will you consider before drafting the before drafting the main pleading? Okay, so you are writing to them a legal opinion. You're writing to them a legal opinion. Okay, you are writing a legal opinion, and in that legal opinion, you're supposed to capture two things. What are you capturing? You are capturing the steps you need to take, and then number two, you are capturing the issues you will consider before drafting the pleadings. Tunaelewana? Okay, now somebody tell me. So that is a legal opinion. So legal opinions, like we've said, they're just letters. It's just a letterhead, and it is it's as simple as it can get. Just a normal letterhead addressed to your client. And then, of course, you know the rule is the FIRAC rule, the facts, the issues, the rule, the analysis, and the conclusion. But you don't have to follow that rule specifically. Okay? What you need to have addressed is the two parts of the question that the question is giving you. Okay? Which is number one, what is the first one? What are the steps you will take? And then what are the issues you will consider? Are we together? Now, tell me. Somebody tell me. What are the steps you will consider? I mean, what are the steps you will take, and what are the issues you will be addressing? Now, if you are going to prepare your legal opinion in this sense, you're just going to have the letterhead, and then you're going to have the facts, and then you're going to have the issues. Okay? So the issues, the first question that you need to address in that legal opinion is what steps? What are the steps you will take? Okay, to ensure that the title transfers to your client, and your client in this question is Joseph. That is Joseph Ngolu. So what steps will you take to have the property transferred to Joseph Ngolu? That is the first thing. The second thing that your legal opinion must contain is what are the issues that you will consider before you draft the pleadings. And then after you give us that, you are going to give us yours faithfully or yours sincerely and sign, and then your client. That is all. That is all you need to have. So the normal legal opinion, and it must contain the two things. This is a legal opinion on, guys, a legal, anytime you speak to a client, anything you tell a client, it is a legal opinion. Anything you're telling your client, even if you're telling your client, if you send a letter to your client telling your client that I want you to bring this document because of this and this and this and this and this and this and this, that is a legal opinion. So it doesn't have to have case law. No. A legal opinion doesn't have to have case law. Okay, it can, but it doesn't have to have. Okay, so don't overthink the question. So somebody tell me, what are the steps you will take to have the property transferred? Okay, so what is the first step you're going to do? What is the first one? And then the second one, the third one, and then the fourth one, or the fifth. What are the steps you're going to take to have the property transferred to your client? Put up your hand, guys. And I've said this question is in civil. It has nothing to do with conveyancing. So don't tell me you will apply for allotment, what. No. That is conveyancing. It's different. It's not, that's not about conveyancing. It's about civil. This is a civil suit. Now, what are the things you will consider? Suing. Guys, we have talked about the procedure. We have talked about the procedure of suing. When we started this class, the first thing in class I did say is that there is a civil procedure. You start from somewhere, you go somewhere, you go somewhere, and you go somewhere. Now, the first point we discussed was taking instructions. Now, you have taken instructions here. Where else are we? What are the steps you will do? In this specific case, what are those things you will have to do to have the property transferred to your client? Guys, Try. I know maybe it's the first time reading an exam question, but they're simple as that. There's no complication, guys. It is just that you are going to overthink it. Do not overthink it. Guys, put your hand up. Yes, Bishar, let's start with it. What is the first thing you're going to do?
Well, the first thing that I will do is to send a demand letter requesting for the administrator to transfer the title.
That is very perfect. That is extremely perfect. Guys, it is not rocket science. That is a simple process. It's a simple process of instituting a suit. Before you sue someone, send them a demand letter, okay? Demand letter. So the first thing you're going to do is you're going to demand from the personal representative. Why the personal representative? Because the question has told you that Samuel, who is our defendant, died in May 2000, but his wife Lucy has obtained a grant of letters of administration, and therefore Lucy Joe is now the administrator. So you send out a demand letter. So guys, when you're preparing your legal opinion, you're going to have the same thing. You're going to have your letterhead addressed to your client, the subject line, okay, subject line, and then the brief facts, that's the small facts, and then the issues for determination, whatever you're going to be considering in your legal opinion. And in this case, the first one is what steps will you undertake, or what steps will be undertaken to have the property transferred to Joseph Ngolu. So in that instance, you're going to introduce your point. How do you introduce your point? Okay, you're going to say, in order to have, you can say it in different words, in different sentences, depending on what makes sense to you. In order to have the property transferred to you, because you're addressing your client, we shall undertake the following steps. Okay, and then you write step number 1, demand letter to the administrator, for instance, or a demand letter, and then you underline, and then you explain, okay, that because this person has died, Samuel has died, and the wife has been appointed as the personal representative, you shall send out a demand letter demanding that Lucy Joe transfer the title of the property to your client, who is Joseph Ngolu, failure to which you shall institute a legal suit. Simple, straight to the point, move on. That is the first thing. So guys, not rocket science, Tuko sawa? As simple as that. Penina, what is the next thing you're going to do?
Okay, Mwalimu, this is just a trial. After sending out a demand letter, after the period that has lapsed, the period that you have specified in the demand letters has lapsed, and there is no communication from the recipient of that demand letter, then you can move to court.
What is the next step? You are explaining. Yes, you are explaining.
Instituting a suit.
Institution of a suit. Before that,
yes,
there's something, you're the one who has read this question. There's something you've missed, very, very crucial. Very, very crucial. Guys, when you read a question, get the point in the question. What is the question talking about? And always, I will tell you this. Okay? I will tell you this. That the examiners or the markers, not really the markers, but the examiner, people that set exams, they're also very busy people. Okay? They're very busy. In that sense that if they provide certain details in the question, they're not doing it for fun. Wamekosa kazi. Why do you think this examiner is telling you that this person died this year, this person bought this land this year, this person did this year? Why is the examiner giving you dates and time? Because the examiner wants you to pick something from that. Everything the examiner puts in the question has a meaning. Okay, so get the meaning from that and then give us the second point. Tua John, yes. Next. Tua John. We can't hear you.
Okay. Can you hear me now?
Uh-huh.
So, civil procedure normally involves timeline. I will consider whether the suit that is to be instituted is time barred, and then if I see that it is time barred, I
Listen,
will
John.
now.
At this time of this of you answering the question, you cannot use the word "you will." You've been given the instructions by your client. You are writing your client a legal opinion. Are you telling your client that I will consider? You already considered now. Right now, as we're speaking, as we're answering the question, the first one, you send a demand. Okay? The second one is still on you, Tua, John. So you have to act. Don't say you will act. Act.
Mhm.
Tua?
Consider the timelines because the suit might be time barred.
You've considered. Listen, John. You've considered. You need to act. Consider and then what? Act. You don't have time. That's why you're doing the legal opinion. You've been given the facts. So from the facts, have you considered the timeline from the facts? And if you have considered the timeline from the facts, now what is the step that you need to do? If timeline is relevant, what is the timeline? What is that you need to do?
The client needs to seek leave of the court before instituting such a proceeding.
John, I want you to listen. What do you mean the client needs to consider?
You will consider.
You listen. And I want you to listen very well. If you have a glass of water, take that sip. Sip that glass of water right now and listen. Okay? Let's go back. Calm down. Let's go back. I come to you with my problems. And I'm telling you, these people I bought land from these people. This time, they've refused. Now, when you are advising me on what to do, and I've asked you, please, John, tell me what should be done so that this land can come to my name. I've given you all the facts. Why are you telling me that the client should consider? Let's go back to the first point that Bishar gave. What is? Send a demand. The first point is send a demand. What was the explanation? That because Samuel died, or because Samuel's wife, Mary Jo, was appointed the personal representative to the estate, you will, or we will, actually we use the word we will, okay, send a demand to Mary Jo demanding them to transfer the title to the name of our client, failure to which we shall institute a suit. Full stop. Now the second one is what point? Joanne, we are still on you.
Maybe someone else to help me.
Nobody is coming to help you. You are on your own. Nobody is coming to help you, my friend Joanne. You are on your own. Okay? So unless something happens that miraculously you leave this world and go to heaven today, you will answer this question, even if I love to come for you physically. Now, still on the question of timeline, okay? Go back to the question, consider the time, and give me an opinion on the time. Is there something wrong with the time? Let's start there, John. Is there something wrong with the time?
Yes, there is, because I can see that 4 years have lapsed since the person who sold the land to him died.
Is it 4 years?
Yes, because the person passed on in May 2000 and the grant of letters of administration were obtained in 2004.
And when did this person come to your office?
On 16th. Yeah, on 16th of August 2018.
So how much time has lapsed?
18 years.
Guys, Guys, when you read a question, again, I'm going to say this and I will keep saying it. Read a question, understand the question, be very intentional with the question. Okay? I've said there's a reason why the examiner keeps giving you the dates, the years, and the time, because he wants you to pick something from it. Are you guys together? So, John, what is wrong with time? Now tell me, what is wrong with time?
Time has lapsed
Mm-hmm.
when the Joseph could have instituted a suit,
Okay.
and therefore now the suit will be time barred.
Perfect. That is your determination. The suit will be time barred. Now, as an advocate, as a wakili, if the suit is time barred, so what step will you take? Now, give us the step now. The suit is time barred. Now, what step will you take? The point is?
You will seek leave of the court before instituting a suit.
Leave to do what?
To file the suit out of time.
Exactly. Extension of time, enlargement of time. So the next thing is an application for enlargement of time. Guys, remember, this is a legal opinion. You are the advocate. Your client is a lay person. Okay. So you've gone through this. You've seen there is a problem with time. Okay. There's a problem with time. So the second thing you need to do as per our discussion is that you need to enlarge time. That once the demand is not responded to, you shall file an application in court, okay, seeking leave to institute the suit out of time or seeking an order extending the time. Are you together? That is exactly what we are saying. That is exactly what we are saying, that a lot of time has passed and therefore we will need to go to court and seek the enlargement of time, extension of time for filing the suit. And that is as per the statute of limitation of the Limitation of Actions Act. That is the second one. And you simply say enlargement of, you can even say enlargement of time and then underline and then indicate that because the time provided for in this, you started very well, in the civil procedure rules, okay, for instituting this matter has already lapsed, we shall make an application to court to seek an enlargement of time and leave to file the matter out of time. Simple. Done. Next point. So John, umeona ni rahisi. So first, remember all times, guys, when you are providing a legal opinion, you are the advocate. Don't tell the client something they should do, or don't say you will do something. Talk as an advocate and say, I will do this, I will do this, I will do this. Do it. Okay? That is exactly what I said. So the first one, demand. Second thing, it is the question to do with extension of time. What is another thing that you will consider or you will do to have the suit, okay? To have the property transferred in the name of your client. Somebody else, Bana. These things are not hard. Just read it, breathe in, internalize, and breathe in again, and then answer. Somebody? And don't be in a hurry, but also be in a hurry. Don't be in a hurry to answer questions, but also make sure you are answering quick. Guys, what is the next thing you're going to do? Guys, you guys mnanipima sana. There's only one person having their hand up, that is Bishar. So you guys don't know. You are in a foreign world. Guys, at least put up your hand. I don't know whether I scare you guys like that. I don't think I'm that scary. Even in real life. So please, just put up your hand. There is no right or wrong. If you don't answer the question, you will never know it. Okay? So there's no right or wrong answer. That answer is what I'm looking for, and then we can correct it as we go. Guys. Okay, sawa. Kegei, Anyanzo?
File a suit on a breach of contract.
You file a suit. So, guys, demand, you've extended time, you've been given leave. Okay, so the next thing is, the third thing that you're going to do is you file a suit. You file a suit. Okay. Now, when you file a suit, you will have to clearly indicate that you're going to file a suit in court and the orders you're going to be seeking. Okay. So the first order you're going to be seeking is, of course, an order. What are the orders you're going to seek? Everybody should be putting up their hand now. What orders are you going to be seeking in this case? What orders are you seeking, guys? Guys. Can we speak? Can we interact? Isaac Kimaru, what orders are you seeking? The first one?
I think it would be an order for specific performance for the personal representative to sign the transfer documents. Those are my thoughts.
That is the first one, of course. You are going to ask for an order of specific performance, compelling the personal representative to to sign the transfer documents, hence making it easy for the property to be transferred to the name of your client. What is the second thing you're going to seek? What is the second prayer you're going to seek? And it should be the first one, actually. It should be the first prayer. Oh yeah. Rafa. Guys, these things are in the question. Rafa?
An order prohibiting the personal representative from evicting him.
Yes, you've been told that your client is almost being evicted. Okay? You've been told there, whatever I've just highlighted there. Okay? That your client is almost being evicted. So you would want to get an order prohibiting a permanent injunction. Okay? A permanent injunction prohibiting or restraining the personal representative. Sorry, my screen just disappeared. A personal representative to that estate, that is Mary Jo. Something is happening to my screen. All right, Mary Jo, from evicting your client from the parcel of land. And then the second one, we talk about the question to do with an order. A specific performance, an order compelling Mary Jo to sign the transfer document. And that is the end of the first part. So at that moment, you've talked about the steps you will do. Demand, extend time. If you get the leave from court to file out of time, you proceed and file your suit. Okay, you proceed and file your suit. So what suit are you going to be filing? That one is going to come later. Now, the second part of the question is, what are the issues you will consider before drafting the pleadings? Any pleadings. What are the issues that you will consider before drafting any pleadings? Now, in your legal opinion, you'll go to the next point. The first point was what steps you will take. Now, the second one is, you write maybe 2 or Roman 2, whatever, or B, you write, what are the legal issues, or what issues will be considered? Issues to be considered before drafting the pleadings, okay? And then you'll be writing down that you have to introduce your point. Don't just throw them, okay? Before drafting the pleadings, the following issues will be considered, or we will consider the following issues. The first issue is, guys, chorus these things, man. At least, if you guys can't increase my salary, I will be in tandem with my fellow teachers to strike. If you don't want me to strike, please answer this question. This is the first thing I taught in this class. It is the easiest thing you'll ever find in your life. So please, I'm begging you. You guys are close to 150 in this class. I want at least 50 hands. If you don't have 50 hands, in the next 2 minutes, I am going to adjourn this class. And if you know me, you know that I don't call it a bluff. I am very serious. If you want to find out, let us count to 2 seconds or 2 minutes. I am very serious. If you're my friend, you know. Ask around. It's 7 p.m. I can adjourn this class right now. Guys, put up your hand. At least 50 of you. You are 150 in this class. Give me 50 hand. What issues will you consider before drafting a suit? Okay. And some of them are even relevant to this case. Actually, they are all relevant in this case. They are relevant in all cases, guys. So if you don't put up your hand, you're simply telling me that, oh yeah, brother, you can do whatever you want to do. Okay. So 50. I mean, show me that you've at least gotten something from these classes, man. You guys are very heartless. You guys are very heartless. You don't care whether someone is an orphan. Please, I am an orphan. Put up your hand so that I feel nice. Eh? So the poll will stop at in the next 10 seconds. And I want to see whether we are adjourning this class or not. You guys will give me a very nice deserved holiday. Guys, put up your hand. Just put up your hand and say something. 50. I won't pick all the 50 of you. You can't. They are not 50 points, so not all of you will speak. So don't get scared. Okay. All right, guys. You guys are very tough-headed. So, what is the first one? Kiari Wamboi. What are the issues you'll consider? Kiari Wamboi. These are free. They are free 5 marks. Pick them up quickly. Okay. Laria, Flavia, next, and then Amina, Soshi. I can't pronounce that one. And then we have Njoroge Masi. And then Dagane Aisha. Wamboi, tuanze na wewe. Guys, can you hear me? Can Wamboi hear me? I think something has logged me out. I can't.
Mwalimu, we can hear you.
But
We can hear you.
He's not saying anything. Or it's me. Sorry. I think something happened to my laptop. I was logged out. Can you hear me now?
Yes, we can hear you.
We can hear
All
you.
right, let's go to Amina. Okay, that one, no. Can't pronounce it. Amina?
It's Shosi.
Is what?
Shosi.
You know where I come from. I can't pronounce those two words following each other like that. Yeah, so what is the first thing you consider?
The cause of action.
So the first thing is the course of action. Perfect. Course of action. So you'll consider the course of action. Okay, you'll consider the course of action. And specifically in the question, the course of action is what? What is the course of action? Amina?
Breach of contract.
Breach of contract. Perfect. As simple as that. Let's go to someone called George Saina and then Flavia.
The next is pecuniary jurisdiction.
A what?
Or say parties.
I was waiting for you to say what you just said first. Yes, I would send the hit squad to come for you there. The parties. The parties. So you consider the parties. Okay. So in terms of parties, before you file, guys, we've discussed these things before. Before you file any suit, you have to consider the parties to the suit. So course of action, in our case, our course of action is the breach of contract. Now, Saina, tell me, who are the parties in this case? The parties.
The plaintiff will be Joseph.
Joseph is
Yes,
the plaintiff.
plaintiff will be Joseph.
The
Yes,
defendant.
Versus the representative of the deceased estate.
What do you mean the relatives of the estate?
Not the relative, the representative.
And who is the representative according to the screen? Mary, Lucy Joe. So Lucy Joe is the personal representative. So you have that as Joseph Ngolu versus Lucy Joe, okay, sued as the personal representative to the estate of Samuel, into bracket, deceased, okay? That is our party. That is our party in that question. Okay, so you'll consider the party. What is the next thing you're going to be considering? Somebody else, quickly. Someone called Dennis Olubi. Dennis Olubi.
Will consider the court with the jurisdiction to hear this matter.
Yes, jurisdiction. You consider jurisdiction. You'll consider the jurisdiction of the court, and in this case, which court has jurisdiction?
Environment and land courts.
The environment and land court. Why is it the environment and land court?
Because the matter concerns land.
Matter concerns land, and specifically it concerns a contract to the right to land. So it's remember guys, this is a question to do with the right to land. Somebody is claiming they have a right over that property. Okay, somebody is claiming they have a right over the property. Right, together, they have a right over the property. Somebody is saying you don't have a right. Okay, so it is a question of who has the right over that land. Okay, now remember that right is coming from a contract. So it is a breach of contract, yes, and that contract gives rise to the right. I don't know whether you get what I'm saying. When you look at section 12 and 13 of the ELC Act, it gives the ELC the jurisdiction to entertain questions to do with land. Now, you do understand that the right to land could also come from a contract. Okay, so this guy who is our plaintiff, who is Joseph Ngolu, is claiming to have the right over this property as a result of a contract. So the breach of that contract is what is giving rise to Joseph's suit. So therefore, you go to the ELC. Are we together? It is not a commercial question. This is not a commercial question. It's not about money, guys. It is not about money. If it was about money, who should pay what, who should not pay what, then we would be going to the magistrate court or the high court. But it is not about money. Guys, the jurisdiction of magistrate courts, the jurisdiction of the high court as a commercial court is pegged on the pecuniary value. But this is not about money. Are you together? It is not about money. So if it was about a refund of this money that this person had paid, the purchase price was 20 million and 950,000, then we would go to the high court, the normal high court, and we claim breach of contract, and then we pray for a refund. But it is not about the money. We don't want the money. Okay, we want the property, and that's why you're being told discuss what steps you will take to have the property transferred to your client. So it's about land, the right to land, and therefore that becomes an ELC. Are we together? Now you consider the question of jurisdiction. So we have considered jurisdiction, we have considered parties, we have considered the course of action. What else are we considering in this matter? What else are we considering in this matter? The obvious things, guys. Somebody, Martin, somebody call Martin. Or Rahab. Let's go to Rahab Mukiama. Rahab Mukiama. Rahab Mukiama is not there. Let us go to, there was a Martin somewhere. He is dropped off. Rachel Gashoya, Gashira. Kefa Omoi.
You will consider the particulars of the breach.
What do you mean particulars of the breach? Which part of Nairobi are you? Are you in Nairobi?
Well, no, sorry. That the matter has not been instituted anywhere else. Res judicata.
My friend, I'm asking you again. Are you in Nairobi? Or are you, where are you?
I'm in Embu.
All right, that is now the headquarters of my men. They can get you there very easily. Please, don't try me. So what I'm saying is this, that point is not correct. Factors you consider before instituting a suit. Res judicata, they will come later, not now. Later, not now. Okay? So make sure. And in an exam, you can't say sorry. You can't tell the marker that, oh, sorry. The examiner will be sorry on your behalf. Yes, Kamunyu Ndungi. What else are we considering here? I just want one point and then you can close this question. We even discussed it when you were starting, guys. Aki nyinyi. Okay. Omwenga.
Consider if the claim is a justifiable claim.
Justiciability, yes. Justiciability, that is also a factor to consider. There's one I'm looking for. Flavia. Justiciability is okay. Of course, the mootness, the question of mootness and everything else. Justiciability and the feasibility of the suit. Yes, you consider that. Perfect. Flavia.
The issue of limitation of action.
Yes, limitation of time. You consider limitation of time. Okay? Limitation of time. Because you've been discussing in the first point. So it comes also here because it's a question to consider before drafting any pleading. Limitation of time. Okay, limitation of actions. That is what you can, and you get your free 5 marks. You get your free 5 marks. But you have to make sure, don't write the whole world in this question. It's just 5 marks. Don't overdo it. Guys, this entire question, you need to do it in 1 hour. Okay, question 1 is 1 hour. 1 hour only. If it passes 1 hour with 1 second, you need to run away from that question. Okay, 60% of people that fail civil is because they didn't complete the question. 3 hours is a very short time. You will be in question 3 and then time is up. All right, now that is first question. You have your mark, so you proceed and complete your legal opinion, yours sincerely, and then you sign. Draft pleadings seeking the appropriate reliefs. Okay, seeking the appropriate reliefs. Now, what pleadings are we drafting here, and what reliefs are we seeking? Pleadings are we drafting, and reliefs we are seeking. So we are not going to draft it because we've drafted these things before. I just want you to name the pleading, and you guys can draft it on your own, and then the remedies we're going to be seeking. Specific things, very, very easy. So tell me, what pleading are we drafting? What pleadings are we drafting? And what are the remedies we are seeking? Let's go to somebody's hand. Rahab, your hand is still up. Rahab Mukiama. Okay. She's not there. Thua John, let's come back to you. What pleading are we drafting here?
We draft a plaint.
All right. What are the remedies you're seeking?
We will seek the ones that we stated before, injunctions, and then we can go for special damages.
Wewe. Nakuona sana. Why am I on a loudspeaker? I don't like listening to my voice. Can you remove me from the loudspeaker, please?
No, you're not on loudspeaker.
I can hear myself.
No, I'm using my phone. So
Which one are you using? Are you using an Intel or Techno?
iPhone 15, 16.
That is not an iPhone. See the way I'm hearing my voice. I don't like my voice. I don't like listening to my voice.
We can also hear too, Malim.
You can also hear my voice, right?
Oh,
Yes,
maybe it's the yeah. Yeah, it's because I'm using my laptop with the earphones and then the phone. I've logged in with two devices. That's why maybe.
Why are you using an earphone? It is 2024. Utanyongwa na hiyo kamba. Hiyo kamba itakunyonga siku moja. Unasikia? Hiyo kamba ya earphone siku moja utajipata tu umejinyonga. Aya, sawa sawa. So that is the question was, you are drafting a plaint, very well, tick. Okay? Tick. As per what Tuajuana said, it is a plaint. Okay. What are the remedies? What are the remedies? The remedies, you've started with special damages. What do you mean special damages? What do you mean? You've not been told any special damages in this question. Okay, you've not been told any. So special damages must be specifically pleaded and prayed for, unless the question told you that. Okay, what are we praying for? Yes, Rahab?
For specific performance.
Yes, the first one is a specific performance, and specific performance is you're compelling that person to sign the transfer. What is the second prayer? What is the second thing? What else are you going to be seeking for? We already mentioned these things before, so I'm just wanting you guys to repeat.
To prohibit the eviction.
So what prayer are you going to be seeking there to prohibit the eviction? What order?
In order to prohibit them from all permanent injunction.
Yes, the permanent injunction. So you pray for permanent injunctions, and then you can pray for cost of the suit and maybe an interest on the cost. You can't pray for damages. Guys, you can't pray for damages. Why? When you pray for specific performance, you can't pray for damages. You can't get those two in the same pleading. You can't get damages for breach of contract, and then you also pray for specific performance. No, you can't get those two. You only get one. So if you want specific performance, it means you still want me to perform. So I will perform, but I can also pay you cost. Okay? But if you want damages, I will pay you damages, but I won't perform, because damages for breach. So let me just breach it and pay you damages. But I can't pay you damages and then perform again. It is very impossible. So you cannot pay for damages where there is specific performance. And then, of course, the only thing you'll get is, of course, the cost. Specific performance, the cost, maybe an interest, and everything else. That is what you're drafting. So we went through drafting of a plaint. We went through each and every step of drafting a plaint. Practice with that question. Practice with that question. Practice with that question and see whether you understand it. If you understand it, that is well ready for an exam. Perfect. So everybody's hand should be down first. If your hand is up, put it down first, because I don't know whose hand is up because they're having a question or because they're.
I have a question, Jactone, if I may.
Yes, you can't now, guys. Listen first. I want you guys to listen. Put your hand down first. There are so many hands up. I don't know who is asking a question. I don't know which one is an old hand. Put them down first, and then we can take questions quickly and go to the next thing we are doing today. Okay. So mikono ziende chini kwanza. And some of you, they're not even listening. Okay. Now, if you have a question, put up your hand. As you put your hand up, let me just explain a few things. The first thing I will explain is the fact that, guys, exam questions are not hard. They're very simple things. They're very, very simple things. So you are going to draft your plaint and you're verifying affidavit only. No accompanying documents. Only verifying affidavit and the plaint only. Okay? Because you're not being told to draft the accompanying documents. Very simple. This is how you get your entire 20 marks and to move on with your life. So don't complicate things. Don't read out of context. This exam question has nothing to do with conveyancing. It has nothing to do with letters of allotment. It has nothing to do with probate. Okay? It has nothing to do with all those things. It is just civil, simple, and straight to the point. Please, 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 always make sure you're not overcomplicating some small things. Let's start with Nasor. Are you Nasa or are you Nasor?
Sorry.
Nasor, all right. Tell us,
Yeah.
what is your question?
Okay, so my question is with regards to the limitation of actions. So this matter, I understand it's a civil question, but it's a matter relating to rights on a particular piece of land. So when we're looking at the timings, should we look at the timings that are applicable on land matters? Should we look at timings on contracts? Which one should we look at?
Now, this is a question to do with land matters, because it is a question to do with transfer. They have refused to transfer you. You know, anything that deals with land is supposed to be 12 years. So of course you regard it as a question to do with land, for the simple reason that I've already mentioned, that the main issue here is the transfer. Okay, that these people signed the the contract. The transfer was not signed until this person died, and it has been almost 18 years. But you will lose nothing at all. You will lose nothing at all if you talk about the 6 years for the breach of contract. The 6 years for the breach of contract. Okay, 6 years for the breach of contract. But to be on the safer side, talk about the 12 years, which is the question of land. Are you together, Nasor?
Yes, we're together. Thank you.
All right. Ibrahim Bishar. Abdi. Are you Abdi?
Yes, I'm Bishar Abdi Ibrahim.
All right, proceed.
Mine is the jurisdiction. In scenario Malimo, when it comes to charges and the bank is exercising the statutory power to sell, and the judge is aggrieved, which court has the jurisdiction? Is it the ELR or the commercial?
Now that is a commercial court, a commercial matter. But in practice, carefully, in practice, you'll see some of them filed in the ELC. You'll see some of them filed in the ELC. But again, it depends on why this person is going to court. Normally, nobody should go to court. Okay? In terms of the bank selling your land, nobody should go to court. So the reason why this person is going to court, okay, will inform the court you're going to. Okay? So, for instance, you will be disputing, you could go to court because you're disputing the existence of the charge, that there was no charge on the property. That is a question to do with the ELC. A question to do with the ELC. Okay? You're disputing the charge, that is the right to land, an interest on land, that is ELC. Okay, so if you're running to court, you're stopping the bank from selling your property because you're challenging you're challenging the existence of that charge on your property. You go to the ELC. Sometimes you will find the spouses of these people. Okay, they will charge the land. They will collude. The husband and the wife will collude. They'll take the money from the bank. They take a long vacation. They squander that money. Once the bank comes calling, then the wife will pretend that she didn't know that land was charged. Now the wife will be, they will collude, and then the wife will go to court and say, oh, They didn't seek my spousal consent. Again, that is a question to do with the ELC. That is an ELC matter. Okay? But if you are purely challenging the commercial aspect of it, then you go to the commercial court. You go to the commercial court. For instance, you are claiming some refund on something. Okay? Or you're claiming that you've paid some money. So if it's a commercial aspect, remember that the question of a charge will have both commercial aspect and the right aspect. So the right aspect, you go to the ELC, but the commercial aspect, go to the normal commercial court. So it depends on why this person is going to court. There are a lot of reasons why they go to court. Okay, a lot of reasons why they're going to court to seek an injunction. Yes, but for what reason? That reason will inform the court you're going to. Are we together, Bishar?
Mwalimu, I'm together, but things went wrong on my end in my orals.
Okay.
And so, Mwalimu, in the same question, when after the demand, what about if we say that we just check on the preliminary objections and you now list the res judicata, the jurisdiction, prejudice, time limitation, that you list on that way, other than specify one by one when you are writing for that legal opinion?
Without discussing them?
No, you just put it, the topic you put it, and then you make it a subtopics.
I'm not understanding your question. What is the exact question? Well, I'm very sure I'm not getting it.
No, I'm saying, when you're writing the legal opinion and you have sent the demand letter, you haven't received, so you want to go for the next stage. Is that, and before you institute the case, you file the case, is something that you check is the PO.
No, there's no PO. There's no PO. PO is not. There's no question about the PO here. That is not your work. That is the work of the defendant to raise a PO if they will want to raise a PO. But if you are told that a PO was raised, then the next step would be to deal with the PO. That is after you file. But remember, you've not filed. You just served the demand. The PO will only be raised after you file. But you've not filed yet. We are still at a very preliminary stage.
Oh, good. Thank you.
All right, so thanks. Omwenga, guys, we need to move to our discussion today. This one has taken us a long time. Jesus Christ, the Son of God, and Mary. Omwenga, quickly, please. There's nothing to discuss in this question. It's just a simple plain and the factors to consider before filing a suit. Don't complicate life. Omwenga?
So I was asking, once you get to part B, you're going to assume the court has already granted you leave.
Don't assume, just write upon being granted the leave. Okay, upon being granted the leave. Okay, the same way we come to part 1, send the demand. Okay, and then you'll write after sending the demand and without, if the personal representative does not transfer the property after sending the demand, then it is a continuation. You're talking to your client. Talk to your client. Tell your client the first thing we'll do, we will send the demand. But if they don't respond, we will file for extension of time. Okay? Once we get the leave, we shall file the suit. It's a conversation. Tuko sawa?
So I'm asking in part B, in drafting pleadings. So you're going to assume.
But you've been told, Omwenga, listen, mute that thing. You've been told to draft. So what you're going to do is to draft. That is what the question is saying. You're not being told to consider anything. You've been told draft pleadings seeking appropriate reliefs. That is the only thing, and that is what I'm talking about. Stop thinking outside the box. Sit within the box. You've just been told draft the pleading. So simply 2 things. Identify the pleading. Number 2, draft it. Whether leave was granted or not, that is not your business at part B. That is a business to be discussed at part 1. Okay? That is something, don't Don't overthink these things, guys. Please, I'm begging you. I'm kneeling down right now and I'm putting my hands in the air, asking you to stop overthinking. Okay? Please, please, just do the question as the question is saying. Draft it. Draft it. Okay? You'll soon be asking me. So we will consider that now we have a pen to draft. Just draft whether you have a pen or not. Because our Mwenga, don't overthink it. Just stay within the line. Okay? Dennis, Olubi, quickly, guys. I'm going to cut you guys off because time.
Mwalimu, just on to what Omwenga is asking. Is there any harm?
You can't ask what Omwenga is asking. I've already
Okay,
answered.
mine now. Mine, please. Part B, is there any harm if in our pleadings we include the notice of motion, certificate of agency, then the plaint?
There is no harm, but you'll come back to this class next year. Okay? I will teach you again because you will fail. There is no harm. Of course, nobody will beat you, but you'll come again and I will teach you and you'll pay me.
Only to do the plaint, only the plaint.
Guys, do what you've been told. Do what you've been told. Guys, draft the pleading. What is the pleading? The plaint and the remedies. Guys, there is no harm, my friend. You will walk out of that exam smiling. You'll go to your house, you'll cook, you will eat. They are chested. But when the results come, that is when you shall know. Don't go extra. Okay? Don't go extra. Just draft what you've been told. Notice of motion is not, if the examiner wanted a notice of motion, they will say, proceed and prepare the necessary application. And when they say application, now you go to the question and ask yourself, which application is this? And then you'll say extension of time. So make an application to extend time because that is the main application that we're talking about in the question. So if you're told prepare the application, go to the question and say, in this question, is there an application? Yes, there's an application for extension of time. Prepare notice of motion, supporting affidavit, and move on. Okay? Don't reinvent the wheel. Are we together, Olubi?
Yes, Mwalimu, we are together. Thank you.
All right, Amina, and lastly, Maura. That is the last question I'm taking. Amina and then Maura last.
Okay, thank you. My question is in line with the 29,000 that Joseph paid. In our question, Joseph is the purchaser, and the rents are supposed to be paid by the vendor according to conveyancing, that is. So can we add
what is supposed to be paid by the vendor?
The rents, the land rents.
Paid who? Who taught you that?
I stand corrected.
Nobody will correct you. Guys, that is exactly what I'm talking about. Guys, you guys are very creative, and that is what is going to make you guys, it will end in serious tears. Serious tears. Okay? Now you just sat down there. Wewe umekaa tu chini ukasema hii 29,000. Mbona yeye analipa? Hafai kulipa yeye. Hii maneno sijafurahia. Mbona analipa na yeye si kulipa? Guys, don't go there. Don't overthink. Don't think outside the box. Just be within the box. This box is too big. Guys, there's nothing. Anybody can pay the rates. If you buy the property without the rates being paid, you will pay it yourself. The land registrar or the collector of rates doesn't care who pays the rates. So long as you pay the rates, it's like getting into a house with an outstanding electricity bill. KPLC will not give you extra tokens until you clear the debt of the person that used to live there. So they don't care who pays, so long as they're paid. The same thing with rates. So guys, stick to the question. Legal opinion, pleadings. Tuko sawa?
Yes.
Thank you very much. James Maura. Yes, James?
Yes, James. Oh, thank you, Jactone. Now, hope this is not overthinking, but in terms of reliefs, I was thinking, where we asked that specific performance, would it be in order if you ask that in the alternative, the deputy registrar of the court to sign the transfer?
Now, that is not your work at the same time. That is not your work at the same time. That is the work of the court, okay, to give an order to sign. Why would you need the deputy registrar? The court will simply tell the person, you, the personal representative, sign the transfer. That's a court order. Why will you need an alternative order? Don't go to the alternative. Just tell the court what you want, and the court has the power to enforce what you want. Okay?
Okay, fair enough.
All right. Thank you very much, guys. You've seen how that plays out. You've seen how that plays out. That is how perfectly you can overthink and get the question wrong. You'll waste time, and then time will catch up with you. But guys, 3 hours is very short, guys. 3 hours before you even put the pen down and think and write your name. You know, like I'm seeing someone in this call having 5 names. Okay. Once you're done writing those 5 names, 30 minutes gone. Okay. So time is very precious in that class, in that exam room. So please stick to the line. What you're asked, 1 + 1, just write 2. Okay. Don't start saying that, oh, but sometimes somebody says it can be 5. No, 1 + 1, 2. Just write 2. Full stop. Move. Thank you very much. So that is how that question is set. You can see very well that they're not hard things. We'll go through past paper questions as we proceed with the life, but you will see that they're just normal things that you will see as you learn. So today I want us to go straight and go to amendments of pleadings, because we've been talking about pleadings all along. I want us to go to amendment of pleadings because we have been having a discussion on pleadings before. And if you look at your course outline, in the last class, we talked about service. We talked about taking out of summons and the question to do with service. Summons and the questions to do with service. That is what we discussed in the last class. And we talked about how to serve, who can serve, where to serve, and also talk about substituted service, how to serve abroad, and also affidavit of service. Now today, I want us to talk about the question to do with amendment of pleadings. Okay, amendments of pleadings. Are you together? Amendment of pleadings. Now remember that once you prepare your pleadings, you are always allowed to amend them. You are allowed to amend your pleadings. You are allowed to amend your pleadings at any time. Okay? Now, there are various types of amendment that we can have. Number 1 is amendment without leave of court, and then amendment with leave of court. Are we together? If you have a glass of water, sip it. Yeah. Sip it. Just sip it and relax. And let us transition now to the class of today. Sip that water. All right. So amendments. So what is amendment? Let's start there. Under Order 8, amendment simply means addition and subtraction. Okay. I'm trying to bring up my plaint very quickly so that we can see how amendments are done and see whether these are things that can give you stress in case of an exam. I don't think so. Where's my plaint? Let me put it up right there. All right, so amendment simply means you are adding something or you are removing something from the pleadings. Okay, you already prepared the pleadings, and this pleading can be either, it could be a plaint, it could be a defense, could be a petition, a statement of claim, could be anything. Guys, it could be anything, literally everything. Anything that is a plaint, a defense, petition, statement of claim, it could be, so long as it is a pleading, you can amend it. How do you amend, or why do you amend? You amend to add or to remove. Okay? Amend to add or to remove something. That is amendment. Addition and subtraction. Addition and subtraction. Are we together? That is the first thing you need to understand. Now, the next thing is the question of how to amend. How to amend. Okay? Now, in terms of amendment, there are various ways of amending. Not various, let me not exaggerate it in terms of various. There's no various, just 2 ways of amending. Okay? The first way of amending is by adding. Okay? That is how to amend. You amend by adding. And you amend by subtracting. That is amendment. And then we have the types of amendments. Okay? There are generally 3 or 4, but the most important ones are 2. The first one is amendment with leave of court. Amendment with leave of court. Amendment with leave of court. So in terms of amendment with leave of court, guys, amendments are very simple. They are more practical than theoretical. Okay? They're very simple, more practical than theoretical. Okay? So leave of court and then amendment without leave. Okay? So let us start with amendment without leave. Now, when do you amend without leave of court? When do you amend without leave of court? Are you guys together? When do you amend without leave of court? You can amend as per order 8 to 1. You can only amend once without leave of court before the close of pleadings. Okay? Now, you can amend without leave of court anytime before the close of pleadings. So, when is the pleadings supposed to close? That is the question. When are the pleadings supposed to close? That is the question. Okay? Now, pleadings close 14 days after the filing and service of the last pleading. Okay? Pleadings will close 14 days after filing and service of the last pleading. And what is the last pleading? What is the last pleading? We will repeat that. Pleadings will close 14 days after the filing and closing of the last pleading. And what is the last pleading? Now, the last pleading could be any pleading. Okay, the last pleading could be any pleading. What do you mean any pleading? A plaint can be the last pleading. A defense can be the last pleading. Statement of claim can be the last pleading. Memorandum of response can be the last pleading. Response to petition can be, So how is that? Let me make it make sense. So for instance, if I serve Bishar, okay, I'm suing Bishar for breach of contract. I serve Bishar with my plaint. Okay. Now, Bishar will have 14 days to respond to my plaint. So 14 days. So if Bishar doesn't respond to my plaint within 14 days, the pleadings will close. And therefore, my plaint is the only pleading and the last pleading that was filed. So pleadings will close 14 days. Okay? Now, if Bishar responds to my plaint by filing a defense, and he has served me with a defense, then I will have 14 days to respond to Bishar's defense. How do you respond to a defense? By simply preparing an answer to the defense. An answer to defense is just like a defense. Statement of defense, just remove the word statement and then write an answer to defense. So when you're preparing an answer to defense, you're simply responding to each and every paragraph of the defense. The same way the defense responds to a plaint is the same way an answer to the defense responds to the defense. Somebody is saying in his heart, template. Yeah? Your heart is just singing template. When you get to KSL, your heart is just singing template, sample. Huh? You need to pray. When you go to church, I don't know what you tell God, but the first thing you need to tell God every day as you go to bed, to remove the demon of templates from your heart. Because you will never understand anything if you keep relying on templates. So I've just told right now, someone is just saying, oh, see, I told template, Dion. You have to see. I will not send nothing, my friend. Listen, you have a plaint, right? You have a plaint. When you do a plaint, you serve it upon the defendant. The defendant will prepare what? A defense. How is a defense prepared? A defense will respond to each and every paragraph, like you will say. Number 1, the defendant admits paragraph 1 of the plaint. The defendant rejects or denies paragraph 2 of the plaint. That is a defense. Okay? Now, if you serve me with that defense, and in your defense, you are raising certain issues, then me as the plaintiff, I will also prepare another pleading, which is now called an answer to your defense. Okay? So that answer to the defense, now I'm the one doing the opposite of what you're doing. Okay? I'll be saying the plaintiff denies paragraph 10 of the defense. The plaintiff admits paragraph 6 of the defense. It's the same thing, guys. It's the same thing. Okay? When I serve you with me as the plaintiff, when I serve you with my answer to defense, you can also prepare your defense or your answer to the defense. In short, we can have an answer to 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 the defense. We can serve each other the whole year. Okay? That can happen. Even the 10 years, we're still serving each other. If you guys like to do that, you can do that. Nobody will stop you. But I'm saying, standard, we have a plaint, respond by a defense. When you serve a defense to the plaintiff will look at the defense and say, oh, this person is not raising new issues. If you are raising new issues, I will prepare an answer to the defense. Okay? And I will send you that answer to the defense. If you look at my answer to the defense and you're like, this person is bringing new things again. Okay? You also prepare an answer to the defense. Evil. So once you receive a pleading, you have 14 days to respond to it by filing something. If you don't file something within 14 days, then that pleading, the pleadings will close. Pleadings close, the meaning of a pleading closing simply means nobody can file anything now. The window, the door of the mercy. Okay? Just like the Bible says that on that day, the door of mercy will be closed. The Lord will be telling you, I don't know you. You'll be looking through the window of heaven and you'll be seeing me there drinking milk and honey. I'll be waving. Yeah? So that is pleadings closing on your face. So pleadings close 14 days after the filing and service of the last pleading. It means before the lapse of the 14 days, you can do anything. You can amend without going to court to seek leave. That is amendment without leave. So when you amend without leave, you have to serve it upon the defendant. What are you serving? The amended plaint. Serve it upon the defendant, or amended defense. Serve it upon the plaintiff. Are we together? That is what we are saying. That is exactly what we are saying in as far as amendment without leave is concerned. Okay? That is amendment without leave. You can only do it once without leave of court. Any other amendment now, you'll have to get leave of court to amend. Okay? That is that. The second thing is amendment with leave. Amendment with leave of court. Now, before I go to amendment with leave of court, make sure you understand that when you do an amendment without leave and you serve it upon the defendant, then the defendant has the right to run to court and strike out the amendment. So you can run to court and make an application to have the court strike out the amendment. Okay? And the court will consider why you want to be this to be struck out and all that. Maybe you are introducing a very scandalous thing, something that happened between the two of you when you are enjoying yourself, and then now someone wants to introduce it into your pleading. You run to court and tell the court, my lord, protect my name. Okay? I am an orphan. And then the Lord, the judge, will say, no, you can't amend this one. As simple as that. That is amendment without leave. Now, the second one is amendment with leave of court. Amendment with leave of court. So amendment with leave of court simply means pleadings have closed. The door of mercy shut. Now, if you want to do anything, whether it is just adding a full stop or dotting an I you have to go to court and ask the court to give you leave to amend the pleading, and you have to tell which pleading. Okay. Now, in practice, what usually happens is that as you apply for the leave, you have already amended. So you have the draft amended copy, you apply for leave, and in that application, you attach the amended draft, and you will be praying and asking the court to grant you leave to amend the pleading or amend the plaint or amend the defense as per the attached amended draft. Okay? That is what you do in practice. Now, when it comes to you writing an exam, just make an application asking the court to grant you leave to amend the plaint to do what? To include or to correct the name. So tell us what you want to amend. Okay? Include it there. Right together. That is amendment with leave. Okay? And you make an application, which is a notice of motion application, plus a supporting affidavit. In practice, it can be oral. You can make an application orally before the court, and the court will give you the orders. So notice of motion, supporting affidavit. Again, somebody saying, please share template. Templates. I will not share anything. You will draft it yourself, but you're going to draft one anyway, so you don't have anything to worry about. And then lastly is amendment by court. Amendment by court. Now the court has a power, suo moto, to amend a pleading if the court deems it fit. If the court looks at the document and says, oh, this thing should be amended, then the court shall prompt the parties to amend. Okay? And then rarely in certain instances, we have amendment by consent. Amendment by consent. This is where parties agree. Okay? Parties agree that indeed we need to amend this part and amend this part. And then they file the consent. Okay? They prepare the consent and saying by consent, the parties have agreed to have the plaint amended as follows. And then you include the amendment. You file it in court and the court will ratify. Now that being said and done, I want us to go straight and amend a document. And then after that, you will become experts in amendments. Rachel Omondi, what is your question?
My question is, when you are talking about amendment without leave of court, you mentioned that you can only amend once before close of pleadings. Do you mean once in number or once during the time before the close of pleadings?
We can only have one amended. Like if it's a plaint, you amend the plaint once. Okay, it means you can't amend today. You serve it upon the defendant. 3 days later, you have another amendment. 4 days later, next week, another one. No, you can only amend it once before the close of pleadings. And then any other amendment, lazima utafute leave kutoka mahakama. Tuko sawa?
Yes, thank you.
All right. So I'm projecting something on the screen. And whatever I'm projecting, any other question? I'm locking anyone out? I don't think so. Amendments are very easy, guys. And you will find a question on amendments. I am not a prophet, but I wish I was a prophet. Nifungue tu kanisa hapo CBD. Hii nikule pesa za watu sadaka. Hapo CBD nifungue kanisa ingine hapo kali sana. Mkuja hapo sadaka ya thao kila mtu. Screen mode, yes, full screen. All right, you can see my screen now. So I'm saying amendment has not been set in some time now, but it might be set. But even if it is not set, make sure you know how to do it. So this is a sample plaint. This is a sample plaint that you will have when you when you're preparing for your exams or when you're doing your. I already shared it in the group anyway. So when you're doing your things, you'll have this plaint here. Okay. At the same time, if you are drafting the question that we are drafting, the question that we discussed when you are starting, you will have this one here. Okay. You'll have, you just draft a plaint like this. You don't have to have the subheadings and everything else, but you can if you want. Nobody will penalize you. Okay. So let us try and amend this plaint and see how amendments are done. Okay. So let's say the plaintiff is a male adult of sound mind, residing and working for gain within Nairobi County, in the Republic of Kenya. That is enough for us to start with. That is enough for us to start with. Okay. So there are a few things you need to understand. There are a few things that you will need to understand. Okay. The first thing you need to understand is the fact that we are going to start with amendments with without leave. Let me just space it properly. So let's say 2 point. That space is fine. Okay. So let us amend without leave first. So we don't have leave of court. Okay. So we don't have leave of court. So therefore there will be nothing here under the fast track. You see fast track, there'll be nothing under it because you don't have leave. Okay. So assuming that the plaintiff is a male adult of sound mind, working and residing and working for gain within Nairobi County, within the Republic of Kenya. Okay. This is very important because some of you, let me put it that there. It is very, very important because some of you, I'm highlighting it in red, no, in green. Don't always assume that Nairobi is in Kenya. Okay. Don't always assume that Nairobi is in Kenya. Okay. Unless the examiner has told you. What I'm saying is sometimes the examiner will tell you that this person is living in Nairobi in another country, a fictitious country. So don't force issues and say, apana, there's a mistake. Don't raise your hand in an exam and say that I think the examiner did a mistake here. We need a correction. You'll end in tears for you. Okay. So if the examiner tells you that Nairobi within Masumbuko country, that is Masumbuko state, for instance, that is why you put it. So just write Masumbuko Republic. Okay, just come back here. The Republic of Masumbuko in the Magistrate Court at Nairobi. Don't force issues and say that apana najua Nairobi ko Kenya. Apana, don't do that. So just look at the question and ask. If the examiner tells you a specific country that is not Kenya, that is what you use, okay? If the examiner leaves it blank, yes, you can always assume that it is in Nairobi. So just always watch out for such things. There are very small things that can deny you marks in certain instances. All right, so let us go and amend without leave, okay? Now, assuming that the plaintiff now is not male, we erroneously say the plaintiff is male, but now the plaintiff is female. So what do we do? Okay, we need to add the female, but we need to remove the male. Okay, so how do we can't delete, you don't go and delete. So for us to remove, we have to strike in red. So the first amendment is done in red. And then the second amendments and subsequent amendments are done in any color. Okay, so this document, if you amend it for the first time, you amend it in red. If you're going to amend it for the second time, you will amend it in another color. So still the red will be showing and other colors will be showing. So we will know that it is a second amendment or a third amendment. Okay. So then the more the number of colors, the more the number of amendments on your document. All right. So for us to remove, we strike in red, and for us to add, we write whatever we are adding and we underline in red. So the first amendment is done in red. And that also means that if you're going to an exam, just carry a red pen. It will not kill you. You could carry a red pen, there will be no amendment, or You could miss to carry, and then there's an amendment. So just carry an a red pen, and that will help you in terms of the things you need to do. Okay, so the plaintiff is a male adult of sound mind. So we are going to come here and we are going to strike out the word male. Okay, we are going to strike out the word male. So in my laptop, I cannot strike with red. I can only strike with black. As you can see there, that male has been struck. If you can see, the male has been struck out. So assume it is red. Okay. Assume it is red. And then after it, or before it, whichever place you like, after it, you're going to write female. And then you're going to underline female. Okay. Again, underline in red. Are you together? So the plaintiff is a male adult, but you remove male, strike male, and add female, and then underline female. Of sound mind, everything else remains that way. Okay. So if you're also told that in the Republic of Uganda, for instance, you're going to come here and strike out Kenya in red, and then after Kenya, write Uganda. Sorry. After Kenya, write Uganda, and then underline Uganda in red, guys, in red. So underlining and striking is done in red. That is how you amend. Okay, that is how you amend. Okay, once you amend that, there are few things that must change. There are few things that must change in every detail. I mean, everything that is amended, any document that is amended, few things must change. If it is a plaint, you will come here where there's a plaint. You see where they've written plaint. You're going to come there and write amended plaint. And then you're going to underline the word amended in red as well. Okay, you're going to underline the word amended in red. Are you together? So amended plaint. Okay, that is the first thing that changes. Amended plaint. All right, and then the next thing that will change is also the date. Okay, the date. So look at the date there. So this date must be struck out. Okay, must be struck out like that in red. Like I've said, it must be done in red. That is red. You strike it out, and then under it, you're going to write. Amended. You're going to write and underline amended at Nairobi this dash day of dash 2023 or 2024, whichever time. Guys, are we together? So that also changes. So the plaint must be indicated as amended, and the date of amendment must be indicated there. That is amendment without leave of court. Kuna swali so far? No question. That is the amendment. Now let us try and amend with leave. The only thing that is going to change if it is leave is come up here and see the word amended plaint. Okay, amended plaint. Under it, you're going to have something in bracket. Okay, you're going to have something in bracket. You're going to write, let me write it like going to be, you're going to write pursuant to Euro Code dated 23rd June 2024. Okay, that is what you're going to have there. Why are you having it there, guys? Because leave, ulipewa nini? Ulipewa leave. This is amendment with leave. So you have to tell us you amended the plan. Who told you to amend it? Okay, you're going to indicate clearly that you are given leave, and that leave is dated the 23rd of June 24. Okay, that is what is going to change. If you are amending with the leave, that is the only thing going to change. Everything else will be similar. Okay, everything else will be similar. So that is how to amend. That is how to amend. That is how to amend. So you can amend anything. You can amend everything. From the word Republic of Kenya, you can have something amended there. Maybe it was not written well. In the magistrate, maybe it is in the High Court now. You strike out magistrate and you write High Court and you underline High Court. The parties themselves, the name of the parties can also be amended. Description of parties can be amended. The facts can be amended. Particulars of the course of action. Specific damages. Okay? Everything else can be amended. Everything here can be amended. Nothing, even the wakili that drawn and filed it can also be amended. Everything can be amended. And once you amend, you are going to come and tell us amended plaint. Write amended, underline the word amended because you are adding it, and then plaint. And then if it is amendment with leave, you're going to write pursuant to the court order or leave of court dated that day. And then you come down and at the date, you strike out the original date and then you replace with amended at this date and then you underline. Guys, tuko ngangari. I don't know what ngangari really means. I don't know what was going on in the minds of the Swahili people and the lawyers when they defined the word ngangari. It's a very weird word. I don't know what it means really. But we are ngangari tuko sawa. Okay, that is how you amend. Now, how do you do it practically in an exam? It is very tedious in an exam because you have to copy paste everything. You have to copy paste everything as you amend. Okay, so in an exam, you will get a sample plaint. Okay, you'll get a sample plaint. Are you guys together? You will get a sample plaint, a sample defense, a sample statement of claim, or even a sample petition. Okay, and then after getting it, you will now get also additional information. Okay, additional information. So what you need to do is you need to look at everything in that plaint and ask yourself, caption, start there. Is there anything to be changed in the caption? Okay, is there anything that is supposed to be changed in the caption? And then you're going to say, no, nothing. Parties, nothing. Description of parties, maybe there's something. So here, what you're going to be doing on your booklet, you're going to be writing, copying the plaint and amending it as you copy it. Okay, so you just go to the, the description of parties, copy it the way it was. So you're going to write, the plaintiff is a male adult. Sorry, the plaintiff is a male. Once you get to the word male, you know there's an amendment there. You insert an amendment. So you're going to strike out male in red and then write female, strike it out in red, and then keep writing as you go. Adult of sound mind residing and working for gain within Nairobi County in the Republic of Kenya. Once you get there, you also know there's an amendment there. So you write Kenya, strike Kenya, and then add Uganda, underline Uganda. Okay, and then you go. So the same thing. That's how you do it in practice. I mean, not practice, even practice, yes, but in an exam, that is how you're going to do it. Okay, in an exam, that is how you are going to do it. So you'll be given a sample plaint and additional information. Additional information is supposed to inform you of the things that needs to be amended. So have a pencil, just go through the question and note the amendment. That amendment will be here, amendment will be here, amendment will be here. So you can just write A to mean amendment, A. So when you write and get to the A, you know, fix an amendment and then you keep writing another A amendment. Keep writing another A amendment. That is how you track it, and then you will be good to go. Guys, that is amendment with with leave of court. Amendment with leave of court. Okay. Now, once you amend something, you have to reserve it again. You have to reserve it again. Reserve simply means you have to serve it upon the other party again, because things have changed now. You have to serve it upon afresh. Serve it afresh. Yes, serve it again, so that the defendant or the plaintiff can get the opportunity to respond. Okay. Now, if you're amending it again, the same things rules will apply. You will come back to the amended plaint and write amended plaint. Okay, and then you're going to write, underline the word amended before amended. Okay, and then you go to the date again. You proceed and strike out the amended date, and then write amended on this date. Together. So exactly, that is how you're supposed to prepare your amendments. Guys, any question? Maswali. Swali is a question, right? Swali. And swala na kuswali, are they the same thing? Alphonse, Owino.
Yes. Thank you. I wanted to inquire whether we can also amend applications.
You can always amend applications. Yes, you can amend applications. Anything you file before the court, you can amend it. You can amend it. You can do an amended application to include. The court allows you, and the rules apply the same way. Applications, you have to get leave of court now. Applications, because there's no clause of pleadings, pleadings already closed. Applications get leave of court to amend it, and then you're going to have amended notice of motion, amended chamber summons. Okay, same thing, same rules. Tuko sawa?
Yes, now.
Okay, guys, that is the question to do with amendments. Tua John. Swali?
I'm asking about the date here, pursuant to leave of court dated 23rd June 2024. The date that you have indicated there, is it the day that you made the application to seek leave of the court, or is it the day that the application was approved?
What is read the statement.
Amended plaint pursuant to leave of court dated 23rd June 2024.
So what is dated 23rd?
The date the court granted leave.
Yes. So the leave, what is dated 23rd is the leave. So the day you get the leave, that is the day. So order. When did the order come out? The order came out on 23rd. That is what you write there. Tuko sawa?
Okay.
All right. Thank you very much. Let's go to Waruiru. Joy.
Oh, I also wanted to ask about the pleadings, whether we can be asked to amend the other applications, but you have answered. Thank you.
All right. Thank you very much. Nganga, Martin.
I just wanted to clarification, because initially you had indicated as if you cannot amend the plaint twice or 3 times, but now, if I've understood you well, you have indicated you can amend even several times. So what's the true position?
The true position is you can amend several times. Wakili, you can amend several times. You can amend several times, but When you are amending without leave, you can only amend once. If you want to keep amending, you have to go for leave now. Okay, you can amend your plaint even 1 million times. Okay, but hizo zingine lazima upate leave. But the first one, you will be required to have the leave of court. I'm trying to upload my bring up my the CPR right there. Another one. So a party right there, you can see there that I've highlighted there. You can see my screen. A party may, without the leave of court, amend any of his pleadings once at any time before the close of pleadings. Before the pleadings are closed. Ati Ng'ang'a, tuko sawa?
Yes, I have understood now.
Yes,
Thank
so
you.
once you have amended once without leave, all other remaining amendments, you have to do them with leave now. Okay? All right. Thank you very much again. Kongoi. All right. Swali lingine. So the next thing that we will need to be doing after yes, even where the amendments are with consent, you amend it the same way and you file the consent plus the amended plate. Okay? Where you amend with the consent, it simply means you've agreed to amend. So you will proceed and prepare the amendments the same way we have prepared it. And then you will file it together with the consent that parties agree to have this amended by consent. Okay, so consent is only to ratify that you guys agreed so that you don't seek leave. Both parties agreed. Once parties have agreed, there's no need of leave. Okay. Are we together? All right. Now, Isabel, guys, you can now ask questions, even the ones that are relating to the question we discussed at the beginning. You can ask.
I have a question relating to amendments, maybe outside the examination context. If you are doing an amendment and you realize that subsequently the amendment you made to the pleading, let's say the plaint, will affect the content of the verifying affidavit and also subsequently affect the content of the witness statement. So are you allowed to amend a verifying affidavit in that instance and also amend a witness statement, or the amendments only apply to the, the pleading in terms of the plaint or the statement of claim only?
All the documents, you amend all the documents. People even amend their statements. You've seen people filing amended statements because you've remembered something that you didn't write, so you include it, or you said it wrongly, you have to include it. Okay, so normally there's really a verifying affidavit doesn't really have anything to be amended because you're really confirming what is there in the plaint. So there's nothing really to be amended in the verifying affidavit unless the obvious things like the caption and everything else, you will amend it. Okay, you just amend it and then swear it again and then serve it upon the parties. So every document you file in court can be amended. List of documents, a list of witnesses, witness statements, all those can be amended. Okay.
Okay, thank you.
All right. Ojako Steven.
Yes, I have a question. Is filing a suit in court without a demand letter fatal to a plaintiff?
No, it is not fatal, but you will not get cost. Okay.
Okay, thank you. Okay, yeah.
You will not get cost. Like, let me give you an example. If you have 2 children that are going to school. Okay, that are going to school, and the rule is in your house that every morning you give them fare if they don't catch the bus, or if they request the bus and they don't get the bus, you give them fare. So that means they first have to request for a bus, and then, or not a bus, you have a driver. They have to go wake up the driver, and then the driver will take them to school. If they don't wake up the driver, then they can claim the fare. Okay, so if they don't wake up the driver, there's no fare. Okay, it means they could have just gotten to the driver's place and wake up the driver, and then they go to school with the driver. So they can't come for the fare until they do that. The same way, when you do a demand, you're simply asking me to pay you. Okay, so had you told me you are going to sue me, I shall have paid you. I would have paid you. So the logic is very simple. You sued, you are hiding. You are hiding with the suit. So you can't claim the cost. But because what is the cost? The cost is the convenience. Okay, the expenses. Okay, what goes into a cost? Okay, what goes into when you've seen people praying for cost, give me cost. What goes into cost? Number one, the cost of an advocate. The cost of an advocate. Number two, the cost of preparing the pleadings, the cost of photocopying, the cost in time going to court. Okay, writing letters, that is a cost. So if you make me do that, hire an advocate, prepare pleadings, file them in court, incur the filing fees so that you can pay me my money, then you will also have to pay that cost. Okay? So that can be avoided by you sending a demand letter. So if you don't serve a demand letter, what the court will be saying is that, hey, you wanted to do it. You wanted to incur the cost because you could have simply sent a demand. Na wangekulipa and you didn't have to come to court and pay all these filing fees and have an advocate. Ni wewe ulijitakia. So you will not get the cost. So if you don't send the demand, you'll just get the orders you're praying for, but you not get the cost. Okay? Except in the instances where the court is saying that now sending a demand would have been impossible or impracticable. But generally, if you don't send a demand, you don't have to. You not get the cost. That is the consequence. But you'll get everything you're praying for except the cost. Okay? The cost of the suit. What if leave to amend is granted by the court and which amendment was not done as directed? What happens? Can the court extend for? No. If you're given 14 days to amend, and you don't amend within 14 days, that leave will lapse and you have to apply for another one. That leave will lapse and you have to apply for another one. And you have to convince the court why you're not amending within the time provided for. Maybe you've been sick. Okay, so the court can extend the leave, or the court can issue another one before or after that one has expired. You can get another one. So remember that if you're given 14 days to amend within 14 days. If you don't amend within 14 days, the leave will or shall lapse. And therefore, you cannot amend anything until you get another leave. Are we together? So yes, Penina, yes, you'll do that. You write password to consent. That is consent. But sometimes you don't need to write password to consent because pleadings have not closed. So most amendments with consent are done without leave of court. That is before pleadings close. So you don't have to write password too. Okay. Same procedure, yes. Can you raise issues of the ADR I don't get the ADR aspect of it. Or maybe that was earlier. Okay, so guys, Isabel, you have a question?
No, sorry, I forgot to lower my hand.
All right, Michael, you guys don't have questions.
I have a question, just a point of clarification. It's about an application for extension of time. You mentioned that we can use a notice of motion. Will it maybe be more max if we use the originating summons to apply for extension of time?
Yes, thank you for bringing it up. Let me clarify it. There are two types of extensions. One extension is done by notice of motion under Order 50 Rule 6, and another extension is done by originating summon. Okay. Now the one that is in the question is originating summon. Now, when do you do that and when do you do this? Let's start with the OS. Now, we have an act called the Statute of Limitations Act. The Statute of Limitations Act. Okay, that is Limitation of Actions Act. Okay, now that act provides for the timelines for institution of suits. So if you don't institute your suit within that timeline and time lapses, you'll have to go and extension of time or enlarge time using the originating summon. You use originating summon, that is Order 37, and you ask the court for an extension of time. Now, that is the first one. The second one is extension of time within the civil procedure rules. Now, when you are extending time within the civil procedure rules, then you're going to do it under Order 50 Rule 6 that talks about enlargement of time. So what is the difference between those two timelines? Now, the statute of limitation provides for the time for bringing a suit. Civil procedure rules don't dictate the time for bringing a suit. The time for bringing a suit is provided for in the Limitation of Actions Act. Now, the civil procedure rules only come in after the suit has been filed, and therefore it provides for timelines for doing certain things. For instance, you can file your defense within 14 days. Okay, you can end appearance within 14 days. Okay, you can file your appeal within 30 days. So those timelines that are provided for within the civil procedure rules, you extend them using a notice of motion and a supporting affidavit. Okay, using a notice of motion and a supporting affidavit under Order 50 Rule 6. Okay, now when you're bringing a suit out of time, it is the originating summon. But again, as I usually say, in practice, you'll find it is a notice of motion. In practice, it is a notice of motion across the board. Okay, because the overriding objective now allows parties in practice to bypass those procedural technicalities. Okay, so just do a notice of motion and then you get your orders. In an exam, I would advise as well, try to do an originating summon. But if you don't know what it looks like, or if you knew what it looked like and it has just escaped your mind before you started writing, do a notice of motion. Why? You will still get your marks because a notice of motion is the default application of all types. So all the instances requiring an application, you can always do a notice of motion and you will get your marks. You will get your marks. So a default application is the is the notice of motion. The default pleading is a plaint. It means you can draft a plaint anywhere and everywhere you can draft a plaint. Okay. The same way, all instances requiring an application, you can draft a notice of motion. But if you know what an originating summons looks like, you do an OS. We will look at the OS as we proceed anyway, so don't have to worry about it. It's a very simple one, the same as a notice of motion, the same way, it's the same thing. It's the same thing. The only difference here is that the OS does not have grounds. A notice of motion has grounds, the OS doesn't have grounds, but the same thing. All those three applications are the same. Chamber summon, originating summon, and notice of motion, they're the same. Okay, the difference is that OS doesn't have grounds, but we will draft one, of course, when we get to 137, and also when we get to interpleaders, which is our next discussion in the next class. So we will look at the OS, how it looks like, which is the same thing as a notice of motion. The only difference is that it doesn't have the grounds. It only has the prayers that you're praying for, and then you go straight to the affidavit, not the grounds. There are no grounds in the OS. Okay. Have I answered you? So always just know the notice of motion, and everything else will be fine. All those things are the same anyway, so we will discuss them. Tuko ngangari, tuko poa. All right, guys. So I will give you back your. No, there's no minute to give back. He's already one minute past the time. So we will resume class this week. Of course, you know how the timetable works. And we will start on the topic that we are calling topic 7. Topic 7, which is interlocutory applications. Interlocutory applications. So we shall talk about appearance and consequence of non-appearance. We shall talk about all those applications, interpleaders, default judgment, summary judgment. It is a very interesting discussion, guys. I'm so excited for this class in advance, and I want you to be excited as well. And I said, please, 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 the only thing you can do for me right now, okay, right now, is read these applications. Don't draft. Please, please, stay away from drafting them. Okay, just understand the content peke yake tu. Kama ni summary judgment, understand what is summary judgment. History yote summary judgment ni nini? Okay, default nini? Okay, mareva, what is that? If it is interpleader, what animal is that? Just understand that. Okay. Once you understand that, when we come back in the next class, we shall prepare one template for all of them, because all these applications, they fit within one template, which is a notice of motion. All of them. So just know a notice of motion and know the content. When you come back to that class, we shall be dropping the prayers and the grounds. So Mareva, prayers, ground, full stop. Injunction, prayers, grounds. Interpleaders, prayers, grounds. So take your time through the week to understand the prayers and the grounds, the content only. The document will come. It is a standard document, a notice of motion. It never changes in death, in life. It is with you. It will never change. Tuko sawa? Don't stress. That is our next discussion. I'm so happy about it. It is a very simple discussion, and then we can start talking about the question of the trial. We're doing very well. Tunafanya vizuri. We are doing well. We are moving at a good speed. Unless you guys want me to slow down or increase the speed, I can. During the exams, we discuss this entire template, entire course outline in one sitting. One day, we talk about everything. So it's not, we can do it. So if you want me to increase the speed, yes, say the word. If you want me to go a little bit slower than the pace we are going at, also. But the most important thing is that you need to understand, like you've seen through the past paper question we've done right now, these things are doable. Just don't overthink it. Don't overthink it. Resist the attempt to be creative, okay? Just do as you're told. Draft the pleading. Hivyo tu. Okay? Thank you very much. May the Lord bless you. And that is the word of the Lord. Amen. All right, guys, I will stop the recording there. Saina, you have a question. You're very late. Time is up. The recording has been